Hey folks, welcome back to the channel. Today we're looking at a tragic case that underscores the severe toll of gun violence. 3 young men are in court, one charged with murder for the death of a deputy, and the other 2 are facing charges as accessories. This case reveals not only the devastating impact on the deputy's family, who now face an unimaginable loss, but also how a single night's choices can shatter multiple futures. It's a grave reminder of the profound and lasting consequences that ripple outward from a single act.
Mr. Moore. Sir, this is Magistrate H.R. Faster. You're here on a criminal matter. Please say your full name, sir.
Kareem Moore.
Blake Moore.
Yes.
Thank you, sir. Your defendant 3, case number 240-60206. You have an attorney. Go ahead, Counsel Clemens.
Your Honor, may it please the court. My name is Adam Clemens. My P number is 77233. I appear on behalf of the defendant who's present on the screen.
Counsel, you wait for him to read and stand mute.
Judge, again, I am moving. I am for the court to grant immediate access to this proceeding.
This courtroom is open.
I understand that, Your Honor. They were asked to leave.
Yeah, that was before, and I was told so. The courtroom is open. If the media wants to be here, that's fine. If the media doesn't want to be here, okay.
I just said they were asked to leave.
Yeah, that was before. That was before. And then I got updated information that if the media wants to be here, they can be here. But right now, okay. Counsel, do you want me to move? And so if you want to get the media here or whatever, or do you want to continue?
My client to have an open court. I want him to have a fair.
It is open court.
So I'm asking the court to adjourn this matter until I can determine whether or not they're coming back.
Okay, I'm not going to adjourn it, sir.
That's denying him the opportunity.
No, there's no denial because before I was told it was closed.
By whom?
Okay. Higher than me. So now, Counsel Clemens, I've been told that the courtroom is open and it is open to the media, and that's fine.
Judge, I waived the formal reading information, asked that he be allowed to stand mute and the plea of not guilty be entered on his behalf.
Thank you. I'm going to enter plea of not guilty. Court dates are November 8th, 2024. Let me sign this. I'm sorry. 10:30. Here we go. November 8th, 2024, probable cause conference, followed by preliminary examination. November 14th, 2024, 1:45. Both matters are in front of Judge Sabri. Let's see what we have. Oh. Okay. So, Mr. Moore, some bond conditions. You're not to possess any firearms or any other dangerous weapons. You understand that, sir?
Yes.
And you're not to have contact with any witnesses in this case. All right. Who's here on behalf of the people?
Matthew Penny for the people, P74079.
APA Penny, go ahead, Esteban, please.
Thank you, Your Honor. We would respectfully request a $500,000 cash bond in this matter. Mr. Moore has been charged with with accessory after the fact to murder of a police officer. He's also been previously charged and bound over on a count of lying to the police as it pertains to this investigation. As part of the 18 or 17 count or predicate act criminal enterprise with which Mr. Moore is also charged here. One of those is a March carjacking that occurred in Clinton Township. During that carjacking, the victim who was carjacked, apparently there was some paperwork in his vehicle because that paperwork with his personal identifying information showed up in Mr. Moore's vehicle when it was searched after it was recovered in June of this year. Mr. Moore's DNA appears on physical evidence that is collected as a part of this investigation that's related to the shooting of Deputy Reckling. For all these reasons, the fact that he is facing a presumptive prison sentence upon conviction that we are confident we will meet our burden for, we are asking for a high cash bond, $500,000 in this matter. We also have news from the Detroit police. The defendant is currently on a tether bond for the pending case in the Third Circuit. He has had multiple tampering alerts as well as low battery alerts in this case. Now that things are speeding up, the allegations are getting a lot more serious against him. We all think that these are things that are must be addressed by the court for the public safety and to ensure his return to court.
APA Penny, you said that he had a pending case.
That's correct.
What's the bond on that?
Right now, it is a house arrest bond with his tether, Your Honor.
So personal bond with house arrest?
No. Oh.
Yeah, there was a bond that was posted. I'm sure Mr. Clements can represent that better than I can at this moment.
Okay. All right, thank you. Anything else, APA Penny?
Not unless the court has any specific questions of me.
No. Council comments?
So the court will recall Mr. Moore was arraigned in front of Your Honor on lying to the police in relationship to this investigation. At that particular time.
When was he arraigned?
On June the 26th, 2024.
Okay.
4 months ago. At that particular time, Mr. Penny represented to you, Your Honor, this court, that these charges will be coming forward. At that particular time, this court set a $100,000 cash only bond, no surety. That bond was then reduced at a redetermination hearing at $50,000 cash and surety with a GPS tether house arrest. I have represented Mr. Moore from the inception of this particular matter. Now, I'm very disappointed to hear from Mr. Penny that he has represented to the court that my client has had tether violations or incursions of any kind. I can tell you as an officer of the court, and I'm sure he will confirm this, that he has not filed one single motion in my client's pending case to answer for any tether incursions. It's disappointing that as his counsel of record, I'm just learning of this today. He's attended every court hearing. He's never missed a court proceeding. When he was arrested at the time of this, he knew that the police were coming to arrest him, and he still didn't flee. He didn't cut his tether off. He's always known that there would be additional charges. So what the court is essentially asking you to do is bypass Mr. Moore's entire slate of conduct for the past 4 months and determine that he's a danger to the community and a fight risk, when for the last 160 days or so, he's demonstrated just the opposite. How many court days has Mr. Moore missed? None. How many new criminal cases has he picked up? None. Has he been compliant with what he's asked to do as far as I know? Yes. So now, because the government originally had suggested that my client was involved with Deputy Reckling's death, and now that their investigation is concluded and they know that he was not the proximate cause of Deputy Reckling dying, now the position is, oh, well, after the fact, he aided in the assistance of someone else who committed the crime. Now they'd still like for you to saddle him with a $500,000 bond. I think the request is offensive. I'm offended by it. I find the fact that the prosecution is asking you to disregard that he has no juvenile history, no criminal history, and even in the offense where they're saying that he's charged with a carjacking that occurred in Clinton Township. I don't have any discovery in relationship to that matter. This apparently is a matter that I believe that had taken place sometime in 2023. We look forward to litigating that. The only thing that Brother Counsel represented is that there was some material in Mr. Moore's car found in June that was taken from the carjacking in March. How does that demonstrate that he participated in the carjacking? And I know that we'll litigate that, but as it relates to bond, Judge, I'm asking for a personal bond because he's already posted a substantial bond in relationship to this matter. He's on tether, he is compliant, and I think that the appropriate thing to do is if you have an issue with how he's behaving with the tether is to file a show cause motion. And I know if the court asks Mr. Penny, because I trust him as a litigator, he will respond to you and tell you that he's never filed a show cause motion, and he nor I have ever gotten a report from the sheriff's department that he's violated his tether conditions in any way. His parents are here in the courtroom today. My client has now procured a job. He was scheduled to start today. And had he be given the opportunity to not be arrested and have to spend the night at the DDC, if I told him to come here with me to be arraigned, he would have done so. And I can say that with confidence because he's never missed court. For all those reasons, Judge, I'm asking for a personal bond on behalf of my client because he's already on house. Thank you.
So, thank you. APA Penny,
Yes, Your Honor.
can you tell me, has there been tether violations?
We have gotten information today that the tether operators have record. Apparently the tether is set up where if there's any attempt to tamper with the tether itself, an alert is sent and logged. And apparently that's what has occurred in this case. I just found that out today. We haven't filed a bond revocation. Part of the reason he was given house arrest was because these charges had yet to come, had yet to be issued, and they're being issued here. So this is the first opportunity for us to bring it up before a court.
And APA Penny, can you tell me how many tether violations that the information you received that has occurred?
Let me consult with the officer in charge who's seated here. Just one moment, please. Three. Okay. We've gotten information that there were 2 low battery alerts and at least 1 tampering notification. A tampering notification is
batteries. Okay.
low batteries.
So the 2, yeah. And whose responsibility for the low batteries?
Presumably that's the defendant's, Your Honor. Nobody comes out to charge his battery as far as I'm concerned, or as far as I'm aware.
Okay. Okay. And then there's one about alleged tampering with the GPS, with the tether
That's
itself.
correct. That's the information
When
I
did
received,
that,
yes.
when did that allegedly occur?
I don't have that information at hand, Your Honor.
Okay.
Judge,
Counsel Clemens, go ahead.
I think the better question should be, because the officer in charge who's seated there for the record is Sergeant McIntyre. He works for the Detroit Police Department. He doesn't work for the Sheriff's Department. He doesn't monitor tethers. It's not his responsibility to submit a tether report violation. And myself, nor Mr. Penny have any reports from the Sheriff's Department outlining a tether violation.
Okay.
And I can assure you that and a lawyer as polished and as careful as an astute as Mr. Penny is, who objected to my client's release, had he known about that, he would have filed a motion to have my client's bond revoked, and that has never happened because the Sheriff's Department has never alerted either of us. So the way I look at this now, Judge, is an ambush tactic by the police department. They never wanted Mr. Moore released from bond to begin with. They objected strenuously at every point. Even once the matter was bound over to circuit court, they asked the court to readdress bond again. So now that I get no opportunity to confront these allegations on the day of his arraignment, when new charges are set forth, I'm not notified in advance. It's just, oh, the officer in charge of the case was told by someone else that your client did this. So because of that, Judge, we'd like for you to consider not releasing him on bond. That's disgusting. And I'm embarrassed by that representation to come through in that particular manner, given the time. Court should disregard it altogether.
Okay.
This young man has been complying with everything that Judge Anderson asked him to do. And that's what the record demonstrates. And if you look on the register of actions, there's not a single show cause violation. And the court should not turn a blind eye to that.
Court does not turn a blind eye to anything, Counsel Clemens.
I'm begging the court.
No,
not
the
to
court
do
has
so.
not turned a blind eye to anything. So in order to say court considers everything which you have said, everything the APA Penny has said, okay? I don't know who's responsible when there's a low battery, okay? Who is responsible to change the battery? Because that may be considered tampering with tether itself. I don't know. But in terms of low battery, 2 instances, and then 1 is alleged tampering with the GPS tether. APA Penny, did that occur on different days?
I don't have that information at hand, Your Honor. I'm just relaying what I have been told, as I've gotten it.
Thank you.
And for the record, I did relay this information as soon as I found out about it to Mr. Clements before we went on the record in this matter. So that would have been about, an hour or two ago when he and I last spoke.
Okay. I appreciate to all that information. Okay. And Counsel Clemens, while you were speaking, Counsel APA Penny, while you were speaking, Counsel Clemens, it appeared to me that he was shaking his head, that some information had been conveyed to him, but I don't know. Is that true? Is that true, Counsel Clemens?
Yes.
Okay, thank you. All right. Anything else you wanted to add? Anything new, Counsel Clemens?
No.
APA Penny, anything new?
I think that's all I have, again, unless the court has a specific question. Thank you.
Thank you. All right. Give me a moment. All right, gentlemen. I had a review of the investigator's report. Okay. Court uses clear and convincing evidence standard, and it's entertaining a monetary bond. Okay. And Mr. Moore as defendant 3, he's not charged with any homicide, any murder. He is charged with accessory after the fact, stolen property, firearms, felony firearms, criminal enterprise, no $500,000 cash surety, but this court does believe that Mr. Moore, he is a danger. So what we're going to do is it's going to get a $250,000 cash surety. I'm not going to put him on a GPS tether. Okay. I will also indicate, Counsel Clemens, this is unaffordable. Is that correct?
Sure, certainly.
Okay, so he's going to get another court date this Friday. That's going to be in front of Judge McConaughey. Well, let me start off. This Friday, November 1st, 2024, 36th District Court, 9 o'clock, in front of Judge McConaughey or Judge Williams, who will look at the bond amount and bond conditions. All right. Mr. Moore, can you step aside? EDC, can you stand by for a few minutes?
Yes, ma'am.
Thank you. Counsel Reagan.
Yes, Judge.
Okay, I have both Wayne counties. Can we do them both at the same time?
I'd like to do one at a time, Judge, if we could.
All right, then, let's go with Mr. DeBose. Mr. DeBose, raise your right hand. Thank you, sir. Mr. DeBose, hold on, let me get this paperwork that does not belong to you, sir. Mr. DeBose, you are defendant 1 of this case. Please state your full name.
Raymond DeBose.
Is it Ramon Ray Lee DeBose?
Yes.
Thank you, sir. Again, case number 24060200601. You're defendant 1. Go ahead, Counsel Reagan.
Your Honor, may I please report Bregan on behalf of Mr. Ramon DeBois, we waive the form of reading stand mute. He has been advised of his constitutional rights, Your Honor.
Thank you. I'm gonna enter plea of not guilty. Court dates are November 8th, 2024, probable cause conference, followed by preliminary examination. November 14th, 2024, both matters are, no, excuse me. The first one is at 8:30. The second one is at 1:45 PM. Both of them are in front of Judge Sabri. Mr. DeBose, while this case is pending, you are not to have any contact with any witnesses, and you're not to possess any firearms or any other dangerous weapons. You understand that, sir?
Yes.
Who's here for the people? Counsel Penny, APA Penny.
Good afternoon, Your Honor. Matthew Penny, P 74079 for the people.
Okay. Go ahead, Esteban, APA Penny.
Esteban, we're requesting a remand on this case. The defendant is charged with murder of a police officer. We have recovered the firearm that was used to kill Deputy Reckling in this matter. It was in a flight path that was tracked by a dog from where the murder scene was to where the defendant was found. His DNA is on that murder weapon. We have a high probability of success in this matter. It carries a life without parole potential. So we are seeking a remand in this matter. In addition, the defendant was on bond from a Troy Circuit Court matter that was, I'm sorry, Troy District Court matter that was, one of the conditions was to not have any contact with his co-defendant, Mr. Goins, who is also to have no contact with firearms, and we see how that went, Your Honor. So we are requesting a remand in this matter.
Thank you. Counsel Reagan, go ahead, please.
Judge, I'm gonna be brief. I note that Mr. Du Bois is 18. I do understand what Mr. Penny is saying, but Judge, I'm asking for some type of monetary bond in this matter. I don't know of any assaultive history that Mr. Du Bois has. Understanding how serious these charges or allegations are, Judge. You know, he was in school, Judge, currently in school, due to graduate. So I'm asking the court, he lives with his dad, so I'm asking the court, Judge, to consider some type of monetary bond in lieu of a remand.
Thank you. Court uses clear and convincing evidence standard when it's entertaining a monetary remand basis, according to Rule 6.106. When somebody is charged with murder, they can have a remand, or meaning no bond is given in this particular matter if, okay, make sure, if the proof of the defendant's guilt is evident or the presumption is great. Okay. This court did have an opportunity to review the investigator's report, hear the representations in this particular matter. The court is going to go with the Rule 6.106. Court does find that Mr. Du Bois is a danger. He's going to be remanded to the county jail. There is no bond. There is no bond redetermination hearing on this case. However, Mr. Du Bois, do you hear me, sir?
Yes.
Okay. Your attorney, even though it's a remand status, meaning this court right now, meaning I, is not giving you a bond. Your attorney, whoever your attorney is, can approach Judge Sabri, who is a judge of record for your case here at 36th District Court, to touch on bond conditions as well as bond itself. Do you understand that, sir?
Yes.
Okay. Sir, that concludes your arraignment.
Thank you, Your Honor.
All right. Yeah. All right. Let's go with Mr. Goins. Mr. Goins, raise your right hand, please. Thank you, sir. Sir, you are defendant two in this case. Case number is 24060200602. Go ahead, Counsel Reagan.
Your Honor, Reagan, on behalf of Mr. Goins, waive the formal reading stamp mute. He's been advised of his rights.
Thank you. I'm going to enter plea of not guilty. Court dates are November 8th, 2024, probable cause conference, followed by preliminary examination. November 8th is at 8:30, preliminary examination, 1:45. November 14th, 2024, both matters are in front of Judge Sabri. Mr. Goins, for you, sir, same bond conditions. One, you're not to possess any firearms or any other dangerous weapons, and you're not to have any contact with any witnesses. Do you understand that, sir?
Yes.
Okay. APA Penny, go ahead, Esteban, please.
Thank you, Your Honor. P74079 for the people. People request a $1 million cash bond in this matter. Defendant Goins was on bond at the time of the murder of Oakland County Deputy Reckling. The condition of his bond at that time was that he have no contact with his co-defendant, Raymond DeBose. He was also charged. He was a co-defendant in that case that was pending before the Troy District Court. He was also ordered to have no contact with any firearms. So he violated because he was arrested with DeBose immediately after the murder, sitting on a porch that did not belong to him, next to him. During the dog track from the murder scene over to where Mr. Goins was arrested, another gun was found beside the one, or other than the one that Mr. DeBose used. Mr. Goins' DNA is on that gun, so he clearly had possession of another firearm. Of the 17 predicate offenses that have been listed under the continuing criminal enterprise with which he is charged, he is accused of committing 16 of those predicate offenses, including 4 carjackings, 4 receiving and concealing stolen motor vehicle counts, as well as 8 counts of carrying a concealed weapon between November of 2023 and June the 22nd, 2024, significant periods of time during which Mr. Goins was under court supervision. The people request this high bond because we believe we have a strong case and also to protect the community at large.
APA Penny, can you tell me what is a case that's out of Oakland County? What are the pending charges?
It is carrying a concealed weapon and fleeing and eluding, Your Honor.
Okay.
That is
And just so
actually
I
one of the
understand-
predicate offenses. I'm sorry, Your Honor. That's one of the predicate offenses that has been charged under the criminal enterprise.
Okay, so just so I understand, out of Oakland County, CCW and fleeing, you said?
That's correct, Your Honor.
Okay, and what was the bond that he was given?
At that point, I believe it was reduced to, I can't speak to that. I think he had a personal bond, Your Honor, and his GPS tether had been removed at the time.
Okay, so, and then he picks up this case along with his other co-defendants, is that correct?
That is correct, Your Honor.
Okay, and does he have any pending cases of carjacking?
He has been charged with carjacking, Your Honor. That carjacking occurred in November of 2023 in the city of Dearborn. He has been waived over as an adult. That's an automatic waiver count, though he was a juvenile at the time.
So what is the bond on that one?
That's on this information, Your Honor.
I'm sorry,
That's
maybe I
counsel
missed it. No, what was the bond for the carjacking out of Dearborn?
He is being arraigned on that right now, Your Honor. It's under this information.
Wait a minute. So
That is part of
there's a
that.
carjacking charge, so I'm looking for it. Oh, yes, it is. I see it.
Count
Number
11.
11, count 11.
And the associated
20.
felony firearm is count 12.
Yeah, well, there's a lot of felony firearms out of this, in this case, but just I want to make sure count 11 is carjacking. Thank you. Council Reagan, go ahead, sir.
I think it's part of their theory of criminal enterprise. Judge, he's not charged with the homicide in this particular case. He was on bond, Judge, for non-assaultive crimes. He's 18 years of age, Judge. I do understand, again, these charges are serious. I think $1 million is excessive, Judge. I would ask for something more nominal. He stays with his mother, Judge. If the court even wanted to put a GPS tether, we'd have no objection. But I would ask for something more nominal than $1 million, Judge.
Okay, well, first of all, Council Reagan, he is charged with count 11, which is carjacking. Him and his co-defendant 1, carjacking.
Yes, ma'am.
So it's not just accessory after the fact, stolen property, CCW, there is a carjacking.
It is, Judge, but he's not charged with a homicide. That was my
No, he's not, but he's charged with carjacking. And not only with carjacking, under court rule 6.106, APA can ask for a remand
That is correct.
if the defendant's guilt is evident or the presumption is great. He has not asked for that. He asked for, which I believe is $1 million, which is unaffordable.
Correct. That is unaffordable.
Okay, so with that is, I am going to give him the $1 million, going to adopt the recommendation. $1 million cash surety. And with that, okay, he's going to get a bond redetermination. Which will be this Friday, November 1st, 2024, 36th District Court, 9 o'clock in front of Judge McConicle or Judge Williams. And this court is using clear and convincing evidence standard to find that Mr. Goins is also a danger. Counsel, APA Penny, did you want to add anything else?
There's nothing else for us to add to the record at this point. Thank you very much, Your Honor.
Counsel Reagan, did you want to add anything else?
No, Your Honor. Thank you.
Okay, thank you, folks. That concludes the arraignment of these three individuals and Mr. Goins.
As we close this case, we're left with the powerful reminder of the irreversible damage caused by gun violence. A deputy's life was lost, and these three young men now face life-altering consequences for their choices that night. It's a tragedy with no winners, only lives forever ruined. What are your thoughts on how the court is handling this and on the far-reaching impact of such choices? Let me know your thoughts in the comments, and don't forget to like, subscribe, and hit that notification bell for more gripping courtroom moments. Thank you for watching. See you in the next one.